Hey, it's Val. Ethical examples of business practices for divorce lawyers. So there's the obvious stuff, right? We all know that because of course we want to have an ethical law practice. So for example, we don't want to cheat our clients. We don't want to rip them off. And of course, we don't want to create unnecessary conflict so that we can end up in a hearing and increase our legal fees. Well, duh, of course we all know that. However, being a divorce lawyer, it requires us to go much deeper into asking ourselves, well, what would it mean to be ethical for this family? What does it mean to run an ethical law practice? And what are some examples of those? So stick with me because I am going to share with you 10 things, 10 ideas, 10 examples of what makes an ethical law practice for a divorce lawyer. And stick around till the end because I'm going to share the best for last. Well, here's the first consideration. No blabbing, right? What I mean by that, of course, is when people entrust us with their family law matter, they are often sharing some of the most private, primal, deep secrets with us, and they're trusting us with that. And so the point being is that you never want to share detailed information with anybody other than your client or the people within your office, unless your client gives you permission to do otherwise. Remember, this is their information, what's close to their heart, their experiences, not what is interesting for us to talk about. And sure, if you've been following me for any time at all, you'll know that I often talk about various situations, various stories that I've come across in my practice. Of course, what you don't know is that I often, almost always, I flip the genders. I make sure that there's actually no opportunity that someone could ever know, hey, wait, I know that person. That's Joe Bloggs who lives down the street. Point being, no blabbing. A second huge example of what is ethical in your practice as a divorce lawyer has to do with what I call the no bogus policy. Now, sometimes our clients, they're going to want us to tell them what they want to hear, as opposed to what the law is. Now, often I'll have a client say, but I thought you were supposed to be on my side, because I might be telling, let's say, a payer of support the actual amount of money that they'll actually have to be paying. Let's say if they go to a court hearing, what would a judge order, for example? So the thing is that even though we want to keep our clients happy, and even if it is tempting to tell them what they want to hear so they don't get mad at us or be disappointed, it actually does them a massive disservice if you don't tell them the bad news along with the good. I always share with my clients when they get very upset and when I tell them about the law and they don't like it in terms of, let's say, well, support and how much they have to pay or how they have to divide their assets. And what I say to them is, you know, when I'm telling you the information, the bad news, and what you don't want to hear, well, I'm doing that because I'm on your side. Because it doesn't make sense for me to initiate an action or go to a contested hearing on something that I know is going to lose. Because now what's going to happen is you're going to end up spending a bunch of money to fight a losing battle. So that's why in my law firm, we always make sure that we have an absolute 100% no bogus rule with our clients. Now, the third example of an ethical business practice as a divorce lawyer has to do with making sure that you don't act in a conflict of interest. Now, that could be where looks like you could potentially be acting for both people at the same time or another party at the same time. Often when clients realize that maybe you are absolutely connected to your client, so let me give an example of this. Let's say, for example, I have a long-term relationship with my hairdresser, which I do. And let's say I acted for my hairdresser on a family law matter, which I have. Now, because I'm close to him as a hairdresser, and because I've assisted him on his family law matter, some people might say, hang on, isn't that a conflict of interest? Well, as you know, of course it's not. Just because we are on this person's side in one context and we know them in another context, of course, doesn't make that be a conflict of interest. And at the same time, people often wonder, well, doesn't that make you a little bit too close to your clients? Doesn't that make you not objective? And I always say, of course it does. I'm not objective at all with my clients. In fact, I want to connect with them as much as possible to ensure that I understand what they need, that I understand what's important to them, and it's a lot more enjoyable. Now, here's the fourth thing that you want to consider when you're thinking of examples about ethical business practices for divorce lawyers, and that is being 100% smoking transparent about your legal fees. Now, in my law office, we bill clients every single week. That's right, every single week. And when we bill them, whether they owe $10 or $1,000 or $10,000, doesn't matter, they're going to get a bill every week, and we're going to run their credit card or remove the money from trust 3 days later. That allows them to have an opportunity to review their account, ask any questions, and we know that by the time we've taken the money from trust or by the time we have run their credit card, we know that the client is likely satisfied with the account. Now, going along with the transparency about our legal fees is we also want to make sure that we give them a detailed account. So the details of all of our time entries, the details of any out-of-pocket expenses, and of course, going along with that transparency, my firm obviously, and I hope this is obvious for you too, is if a client has a question about their account, and sometimes, there might be a double time entry by accident, or there might be a disbursement that was charged twice by accident. Well, accidents do happen from time to time. The thing is we always want to make sure that we don't charge our clients for asking about their accounts. We always want to make sure that we stand behind our accounts, that we're completely transparent, and what that really does is it increases our clients' trust in us. Of course, they do know when they're meeting with us and we're getting stuff done that they're going to be paying for that. When they're emailing us and having discussions with us, they know they're going to be paying for that. And when we are transparent about our fees, it really increases our clients' trust in us. And isn't that a great thing? Let's dive into the sixth example of an ethical business practice for a divorce lawyer. You want to make sure that you stay in communication with other lawyers, with the court, and with your clients. Now, this was something that tripped me up when I was a baby lawyer over and over and over again. The thing is that somebody would ask me this hard question, so I didn't know how to just answer it off the cuff. And it meant that I was going to have to get around to doing some research. Who likes research? I certainly don't. But I have to sit down, do some legal research, find the answer, put the answer in a memo, and well, it would end up taking a long time, a lot of the time. And so instead of getting back to my client and saying, hey, got your question, I'll be able to get an answer to you next week or the week after next or whenever, I would instead stick my head in the sand, ignore the question and wait maybe till they called back or reached out again. And of course, by the time I actually got around to answering the question, the client was enraged and completely ticked off, and their trust in me was reduced significantly. So what you want to do is make sure that even if your answer is, great question, I will be able to answer that next week when we talk next. Boom chakalaka. There you have it. You have now communicated. Or when a lawyer on the other side of a matter has a question for us, or we want to set a meeting. I just had this recently in my practice. I've been having a bit of a hard time tracking down my client, but I finally have a meeting with my client set. So instead, I say to the other lawyer, rather than just ignoring him and waiting until I've met with my client to get back to him or her, I say to that other lawyer, I'm meeting with my client next week and I anticipate getting an answer to you within a day or two after that. That way, the lawyer on the other side doesn't get enraged. Our client sees us communicating with the other lawyer, and that makes them feel like they're in good hands. So it's a win-win all over the place. And generally, you can see there's a bit of a theme here, is that when you are diving into being ethical and using these examples of being ethical as a divorce lawyer, because again, being that divorce lawyer is a very big job. Our clients are entrusting us not only with their divorce, but the whole context of their lives, their future, the future of their children, the future of their finances. So the more that you can engage in such ethical practice examples, the greater your clients will trust you and the more thriving your law practice is going to be. It's a win-win all over the place for everybody. Now, remember how I said that there's the usual ethics stuff that lawyers have to get engaged with? Well, that makes a lot of sense. And for divorce lawyers, we have to go a bit deeper. Well, here's one that I think is an absolute must for divorce lawyers in particular. What you've got to do is you have to get qualified to become a mediator. Now, I'm not saying that you actually have to become a mediator in terms of mediating other people's cases. What I'm saying is you want to get those qualifications. When you have the qualifications and get certified to be a mediator, what you do is you have coursework and practice work that goes way beyond anything that law school ever taught us. It teaches you to dive into understanding why your client is setting out the positions that they are, understanding why the other side is setting out the positions that they are. Maybe somebody might seem stubborn on the outset as to why they're taking a certain position, and I'll give you an example of one I've seen in my practice. There was one case where the mom and the dad were trying to negotiate a parenting plan. The mother was absolutely adamant that the child would always have dinner at her house, as opposed to with the dad. And the dad was really pushing for the child to have dinner with him. He wanted to have that opportunity. So on the surface, I'm thinking, well, why is my client being such a jerk about this? At the end of the day, that's the kid's dad, and the child should be able to have dinner with the dad. Well, uncovered a little bit more, and this is what mediation skills teach you, is to get curious, say, well, how come that is important to you? Well, what I was soon to discover was that dad, although he's a great dad, by 5:30, 6 o'clock, he was probably 3 or 4 beer in every night, and she did not want him parenting in that state, and certainly didn't want him driving their children in that state. So the thing is that when you have those mediation skills, it teaches you to uncover what's behind people's positions. It makes you a better lawyer. It makes you a better negotiator. Oh, hey, it's me. Interrupting a little bit because I want videos like this to reach more people. So if you are enjoying what you see, if you're finding it helpful, please hit the subscribe button, which is somewhere up there. And also tell me, what was the biggest takeaway you had with respect to this video? Leave it in the comments below and I will answer every comment, every question, because that's what I do. Now, the seventh thing, the seventh example of being ethical in your law practice is doing the right thing. Now, of course, on the surface, that seems, well, of course we want to do the right thing. But sometimes, I have to admit I've been there myself, maybe our ego gets in the way. Let me tell you a story that happened to me within the last couple of weeks as I record this. So there's another lawyer on a matter I have, and let's just call her Jerky Janice. Jerky Janice, well, she's a jerk. And I find that she is unnecessarily combative, and I find that she's rude and condescending to my clients and other counsel. I really don't like working with this person or having matters against this person. And in fact, I think she brings people to litigation way more often than she should. Well, let's just say the clients had done a mediation, they had come to a resolution, and as the agreement was being drafted up, well, things began to fall apart. Now, I was absolutely certain that if I went to court, I was going to be able to, well, mop the floor with Jerky Janice. I was very certain about that. Let's just say I've been at it way longer than she has, lots more experience, and she was taking an unreasonable position. The point is this. Jerky Janice wanted my client to concede a point of, well, about $2,500. Well, court was going to cost a lot more than $2,500 to my client, but I really wanted to really show Jerky Janice, well, what it feels like to lose. And I wanted her to lose. And then my very brilliant legal assistant, Bruno, says to me, Val, is this really about what's important for the client here? Because think about how much money she's spending and think about how much stress this whole matter is causing her. And of course, my client's amazing and she's just like, yep, sure, Val, whatever you say, I think that's a great idea, etc., etc. And it made me kind of go, wow, you know what? You're really right about that. And so in this particular case, doing the right thing wasn't going to court and being right and mopping up the floor with Jerky Janice, even though that would have been really fun. It was really about doing the right thing for our client. For our client, it was better that the chaos of this ongoing nightmare of litigation stop, that she have a final deal, and that she concede a very small proportion of what ongoing court would have cost her. So, you always want to do the right thing. Now, this 8th example of an ethical business practice, it's kind of amazing how many people don't get this because it's so obvious. And let me just tell you what it is. For goodness sakes, be on time. Be on time for court, be on time for meetings with other lawyers, be on time for meetings with your clients. There is no excuse not to be on time. As I record this, I recall a situation where I actually have an associate that used to work for me that I stopped working with. Why? Because this person could never be on time. They showed up for court late, they'd show up for office meetings late, and when they'd have meetings in the office with their clients, they would leave their clients sitting out there waiting for them for 20, 30 minutes. Really unfortunate that this person just couldn't be or wouldn't be on time. Now, I have ADHD, and if I don't have little alarms for absolutely everything, oh hey Val, time to get up and get on with your day. Oh hey Val, you've got an appointment in 2 minutes. Oh hey Val, really, I have to set alarms for everything. You think, even when I'm heating something up in the oven, I have to put an alarm on, because if I don't, I will get distracted and off I go and I'll forget what I was supposed to be doing. There is no excuse not to be on time. There's one business person in my province, gosh, I don't know if he's still alive anymore. He would have people that worked for him for 20 years. If they showed up late for a meeting, he'd fire them. Now, that sounds draconian and terrible, doesn't it? But guess what? How well run do you think those meetings were? Pretty well run. Did people just straggle in at whatever time? Absolutely not. So when we're on time, it makes our clients feel valued. When we're on time for court applications and our clients know that we're on time, guess what? It makes them know that their lawyer cares about their case, is organized, and it increases, yes, their trust in us. And also, when we're on time with other lawyers, well, we don't start off all of our meetings with the other person being irritated with us. So I can't stress it enough. Being ethical as a divorce lawyer requires you to be on time. So the 9th example of an ethical practice for a divorce lawyer is doing what you say you will do when you said you will do it. And and this is one where I'm sharing this with you because I actually had a massive failure on this relatively recently. And it reminded me that when I say I'm going to do a certain thing by a certain time, it's important to my client, the opposing lawyer, all the parties, including in this case, the arbitrator, other lawyer, that I do things when I say they're going to be done. In this particular case I have, well, fairly high conflict. Let's just say it's really high conflict. And in that particular case, what happened is that I had dropped the ball on some of the tasks I was supposed to do by a certain date. Now, those tasks that I was supposed to do, well, they were actually disclosure stuff that my client was supposed to do. Well, I had advised my client about that disclosure. My client gave me the disclosure well in time, and it was me who dropped the ball about disclosing that disclosure to the other side. Well, what ended up happening was that it unfortunately impacted my client's credibility. Now, of course, I threw myself on the sword and said, yeah, you know what? That's my bad. That's not my client's bad, but it still detracted from the process. So the other side was legitimately upset that the disclosure hadn't been done in time. Time was wasted in the process because the other lawyer got to go on and on and on about how my client was resisting disclosure even though it wasn't about him and even though I admitted that was my fault. At the same time, it also reduced my client's trust in me. So the point being, whatever it takes, whether it's appointments in your calendar, checklists, you name it, make sure that you do what you say you're going to do when you said you were going to do it. It is so important for your relationships with the court, with mediators, with arbitrators, with opposing counsel, and of course, importantly, your clients. Now, I saved this one for last. It's, to me, the penultimate, absolute, most important thing that you could possibly do. And again, this isn't about your usual ethical business practice examples. This is about you being ethical as a divorce lawyer. And what I'm about to share with you is the importance of not always following your client's instructions. Putting it better, refusing to accept instructions from your client that are completely stupid or completely incorrect or ones that won't serve them. So I'll give an example of this. Relatively recently, I had a case where one of the parties wanted to remain in the family home. That was the one parent of the children. That particular parent made a fraction of the other parent's income. Well, the other parent felt that they wanted the house because they made more money and they wanted to be able to keep the house and keep the kids and all of that. Well, here was the problem. The parents were in a shared parenting arrangement, so that part was worked out. And the house had a suite in it. Now, I don't know what your jurisdiction is like, but in my jurisdiction, if people actually own a house and that has a mortgage helper, like a suite, it can often end up being much less expensive to remain in the house than if they sold the house and took the proceeds of sale and saved it or put it onto something else, like buying a condo or a townhouse. Well, they end up being backwards financially in a huge way. Now, in that particular case, my client, well, they really couldn't accept that it made more sense for the other parent to stay in the house. Let's just say my client had a lot more resources than the other parent. And my client said, nope, I want the house to be sold and us to divide the proceeds. Again, if the house was sold, they divided the proceeds, these kids would no longer have a yard to play in, and mom, who was struggling financially already, would have been putting most of her income into either paying a mortgage and strata fees or a very high rent. Literally nobody would have been served. Sure, on the face of it, my client could have had the house sold and divided the proceeds in a way that was his right. But the thing is that wasn't the right thing to do. So I refused to take that kind of a matter to a court in front of a judge and say, yes, I understand that this family, the children, would be way better off if this house wasn't sold, but my client wants it to be sold anyway. Now imagine how that would have looked to the court. Imagine putting forward an application like that, what that would do for the court's opinion of me as a lawyer who wants to always appear reasonable. So in that particular case, I just couldn't convince him, and so I withdrew as counsel because I wasn't going to take stupid instructions like that. So think about it. If you have a client pushing you to do something that you know just isn't right, well, think again about taking those kinds of instructions. So this is Val. I am so glad you're here. And in this video, I have shared with you the 10 examples of being ethical business practices for divorce lawyers. Much, much love. If you found this video helpful, and I hope you did, please give it a thumbs up. Because if you do that, then this video will be able to reach more people. And as well, if you want to stay in closer touch with me, please ring the little bell icon so that you can subscribe to this channel. This is Val. Much, much love.